Okay, so welcome to our webinar today. It is Tuesday, April 7th, and we are here to talk to you about prenuptial agreements. As many of you know, prenuptial agreements are one of my favorite topics. Z Family Law launched a campaign called Tie a Tighter Knot on Valentine's Day this year of 2020. Tie a Tighter Knot is a campaign that was designed to bring awareness to and information about prenuptial agreements and postnuptial agreements and relationship agreements in general and how important they are. With us today, we have Karen Robbins, Esquire, as well as Neil Tyra. I'd love to hear a little bit more about each of you and what you do and bring to the table. So Karen, tell us a little bit about yourself.
Hi, Christy. Thank you for having me here. My name is Karen Robbins. I'm an attorney. That's my by training. And what I do is I help people have meaningful and productive conversations in order to make decisions about the things that are important to them in order to enter into a marriage, to remain in a marriage, or to leave a marriage and can reconfigure their family. And I do that with traditional legal techniques, because that's obviously the way I was originally trained. But I also help people do that in my work as a mediator, as a collaborative law professional, and as a parent coordinator. And I do that mostly in my offices in Frederick County and in Montgomery County, Maryland.
And Neil Tyra, tell us your claim to fame.
All right, so I am primarily an estate planning attorney in Rockville, Maryland. I have migrated to estate planning, having started originally in my legal career as a personal injury attorney and then adding family law to the mix. I practiced in those areas for about 15 years. And then as my kids got a little older, I wanted to decouple myself from the courthouse. And so I moved on to estate planning. And it's really kind of dovetailed nicely with as I get older, my circle of friends and associates are all in that age where starting to think about end of life decisions is actually something that we all spend some time doing. And so it's been really rewarding to add estate planning, wills, trusts, and the like to my practice. I also focus on doing guardianships, primarily third-party guardianships for reconfigured families, as Karen was talking about, which is one of those rewarding things that you can do in law where everybody loves everybody at the end of the day. So that's primarily where I spend my time. I'm also the host of what I'm happy to say is a very popular podcast called The Law Entrepreneur. We just celebrated our 4th year broadcasting podcasts having to do with those folks who are starting a solo practice or want to build a solo practice. And I'm lucky enough to have really great guests like Christy Zlatkus on to help build my audience and provide that value and that service to the community of solo and small firm practitioners.
I will say I will put a plug in for Neil's podcast. When I decided to launch Z Family Law about 17 months ago at this point, I listened to The Law Entrepreneur over and over and over again. And it really is a great podcast. So if you haven't listened to it, please do.
Thank you.
I'm going to put in a huge plug for, as someone who has been an inspiration to me, Karen Robbins, her blog. She blogs about family law issues, and she had a really, really good one about some of the issues that are going on right now. And we shared that on our Facebook page. And if you haven't read it, please go do so. Okay, so let's get into our topic for today, which is prenuptial agreements. So let's start with the basics. What is a prenuptial agreement? Karen, do you want to start with that one?
A prenuptial agreement is simply a contract. It's a marriage contract. It's not something, people treat it as something that's new and unusual, but many religions have had marriage contracts for a long time to talk about the roles of each party and their duties in a marriage. And that's really what a premarital agreement is. It's a conversation about what I need and what I want going into a marriage for each party, and what we want and what we expect as a married couple. What are our rights and what are our responsibilities, and what do we expect?
Neil, do you have any additional thoughts on that? I thought that was a great explanation, but.
No, I think that pretty much covers it. I think that recognizing that that prenups and postnups have been around for a long time. They're not anything new, and they're not just for a selected group of individuals. A lot of people think, well, I have to have a lot of money or I have to be famous in order to justify having a prenuptial agreement. Nothing could be further from the truth.
So let's say you're already married and you're now regretting your decision to not have gotten a prenuptial agreement, especially after listening to this webinar where we're going to go through all the things we can put in a prenuptial agreement. What options exist for already married couples? Neil, any thoughts?
Well, yeah, I think it's really comes as a great surprise to a great many people is that you can do an agreement after you get married. I know I had a lot of folks that came to me when I was practicing family law and said, wish I'd done a premarital agreement, but we're married now. And I said, well, actually you can. And in some ways, it's equally as valuable. In some ways, it's even better or maybe a little easier to do because you've had a little period of time operating as a married couple. So absolutely, you can add postnuptial agreements as they're called, to your quiver of arrows.
Well, I agree with Neil. I've actually really enjoyed working on postnuptial agreements, but postnuptial agreements also aren't just for people who didn't get a prenup. They can be your prenup modification, for example.
Sure.
Let's say your life circumstances when you got married drastically changed in the first 10 years of your marriage. You probably should revisit your prenuptial agreement and update it with a postnuptial agreement. I like to say that a prenup is a living document. It lives and it breathes, and it should age with you. It's not something that should be static and staying the same. So another one that I wanted to talk about to make sure that we're covering it is lately I recently heard the term called no-nup. I'd never heard that before. I always called them relationship agreements. But for those of you who are not choosing to legally tie the knot, but you do have legal entanglements, such as if you're going to have any joint debt or joint assets, or you're going to live together and share your finances, or you might raise children together, but you're choosing to not avail yourself of a legal marriage. There are contracts for you too. And I think those are sometimes even more important because some of the legal protections that exist for married couples don't exist if you don't take that legal step. And you can kind of create a lot of your own legal protections for yourself, but also for your partner. So we started to touch on this. Neil, are you?
I would still go so far to say, Christy, that a lot of people, the line of demarcation about a serious relationship, aside from a marital ceremony, is we decided to buy a house together. And I'm going to tell you that the first thing you should do before you buy a house together is to do this no nuptial or this relationship agreement, because you are just playing with fire if you do not.
I've recommended that repeatedly anytime you're going to get real property involved. If you're going to buy a house together, there's just way too many things that could happen that you really need to protect each other. Even if your relationship isn't going to break down, you can protect each other in other ways as well, of what's going to happen if a tornado hits your house. How are you going to divide insurance proceeds? How are you going to spend them? So many different things that could happen. What if one of you does decide to leave? What if one of you gets sued? You can answer a lot of these up front and have a plan for what's going to happen to that property that protects both of you. So I'm going to use the term prenup going forward, but note that unless we specifically state otherwise, the things that we're talking about do apply, whether it's a prenup, a postnup, or a relationship agreement or no-nup. Again, we'll identify if one of those does not apply. But for simplicity, what kind of people get a prenup? Karen, who walks into your office to get a prenup?
I'm sorry, who was that for?
Karen.
So a lot of people come into my office for a prenup. I think the question really is who should be getting a prenup, not who comes in, because traditionally the people who come in are the people who are having their second marriage, or they have significant premarital assets, or they have some other things that they want to protect from their life before marriage. And I don't think that's true anymore. I think that everybody should have a prenup at this point.
I agree, Karen. You said something interesting on our prep call about Generation X who's getting married later. Can you share that? I think that's really insightful.
Well, back in the old days, when the millennials, the Generation X's, the Yers, and the Zers, of which I am not one of them, back when they were children and their parents were getting divorced, divorce was something, the process was something that looked backwards. It was a lot of blaming and shaming. And because it was so involved in blaming and shaming, these kids were scarred for life from their parents' divorces. And because of that, they're waiting longer. That's what the statistics show us. They're waiting longer to get married. And when they get married, they are bound and determined not to do it the way that their parents did it. And luckily for them, the divorce process has moved forward a lot since their parents got divorced, because now litigation isn't the only option. There's also mediation and there's collaborative divorce, which are both forward-looking, problem-solving methods of resolving the end of a marriage. And so because these millennials and X's, Y's, and Zers are now getting married, they want to make sure that they're not going to get a divorce like their parents. And so they want to have the conversation about what they should do. And they want to have an agreement that talks about what their rights and responsibilities are in the marriage and what their rights and responsibilities are if the marriage doesn't last.
So, Neil, if I'm a young 20-something fresh out of college, I'm newly in love, or I guess I've been in love and I'm now engaged and I'm looking at flowers and dresses, why do I want to sit down and talk about a divorce? What should I?
Well, I'm kind of one of those people that looks at life from a very practical standpoint, and in many ways from a mathematical perspective. And that probably alludes to one of my previous lifetimes where I was a systems engineer for many years. So that's the way I think. And when you look at it statistically, right? I don't care what age you are. When you look at it statistically, the majority of people who get married, sadly, or even if you extend it, the majority of people who are in a committed relationship aren't always going to stay so. So you have a far, more likely chance of splitting up than you do staying together. So just from that perspective alone, you're more likely to need this protection than not. And then the other second practical matter is, I love what I do. I love other attorneys, but let's face it, attorneys get paid to do what they do. And of all the things that you to spend money on later in life, to spend money to help dissolve a relationship equitably is money that you could have spent otherwise. So if you just take the romance out of it, take the personalities out of it, you just look at it from a pure numbers perspective, it's in your best interest, regardless of how old you are, what assets you have, what your relationship has been like. It's in your best interests to get a prenuptial agreement done.
So without disagreeing with a single thing that Neil said, because I absolutely 100% agree with all of it. Absolutely, I do. I want to put the romance back into it.
Yeah.
Because for me, I think that a prenuptial agreement is one of the most romantic things you can do. I know that sounds completely crazy, but hear me out. If you can look at your partner in the eye and say, I love you so much that no matter what happens, whether someday I don't, whether someday one of us gets injured, whether one of us has a drastic life change, no matter what happens, I'm going to ensure that I treat you with the same dignity and respect as I have for you today, and that as I treat you with today, because I'm going to require that of myself, because I'm going to put it down on this piece of paper that's binding. As Karen said earlier today, it's better than hearts and flowers. That to me is truly romantic. It's saying that I'm going to require this of myself, even if I'm not feeling it, even if that's not where I'm at that moment. And sitting down and talking about your future plans, talking about your budget, your plans for raising children, your plans for taking care of your aging parents, your plan for saving, all the different things that you're going to do in your life. And putting that down together is a type of security that you can't get in any other way. And I would go so far as to say, I don't have the statistics on this specifically. I haven't seen them. If anyone ever finds them, please send them to me. But just from anecdotal evidence, those who get prenups tend to not come back in my office and get a divorce. And I think it's because they did sit down and make this plan. What do you think, Karen?
Well, so Christy, I agree with what everybody said, and I have another perspective on it as well, which is that, when we grow up with a story about what marriage looks like and what finances look like. And when we meet somebody else, we assume that our story is the story. And we assume that their story is the same as our story. And a lot of times it isn't until after you've gotten married and maybe had a kid or two that you realize that the stories are different as to what constitutes a marriage and what everybody's supposed to do and how you handle the finances. It's different. And a lot of the folks who I see come into my office when they want to reconfigure their family or get a divorce are those people who never had the conversation about how my story differs from your story and how we can develop a shared story for our marriage. And that's what a prenup does. It helps people have that conversation so they can develop that shared story about their marriage and about what is going to happen. It's a hopeful thing. It's a thing that we're saying, if we develop a story together, then we won't be part of those statistics. And if we are part of those statistics, we will be part of the statistic that says, yeah, our marriage didn't make it, but we ended it in a way with dignity, in a way that didn't hurt our children, in a way that enabled everybody to move forward.
And just to caveat that point of view, which I think is spot on, one of the things that we talk about in estate planning, one of the questions we ask clients is, would you rather have your life planned out by you and your partner, or would you rather have the state determine what's going to happen? And while I have tremendous respect for the work that the legislature and other attorneys have done to craft the laws surrounding the dissolution of marriages in an equitable fashion, the fact of the matter is they write the laws to serve the greatest common denominator of relationships. And it's a one size fits all. And what we as practitioners know at our core is that one size does not fit all. And so therefore, crafting that agreement gives you the opportunity to make the decisions for yourself and your spouse or your partner to what is important to you and how you want to see life continue if you don't continue as in a relationship.
Thank you. The only other thing that I want to say on the subject of who is a prenup or a postnup for, I really want to put a plug in for stay-at-home parents, whether you're a mom or a dad. Alimony laws are fast changing in, I would say, most jurisdictions in the United States, certainly in the local jurisdictions. And if your family is making the choice that someone should be a stay-at-home parent, the protections are shrinking for you. I talk to my colleagues all the time about how birth control in the 50s got women out of the house and into the workforce. That's where they want to be. Well, men and women, if you want to be in the home and you want the protections of some support while you get back into the workforce, or if you want to stay at home, post a separation, this is something you and your spouse or you and your partner really need to discuss in advance. For the most part, there's not going to be a lot of help there. There can be, but you're going to have to fight for it, and you're going to have to prove it, and you're going to have to work on it. So if you and your spouse want to make that agreement that, hey, parent A is going to stay home while parent B works, and parent A's responsibilities are going to be A, B, and C while they're home, and parent B's responsibilities are going to be D, E, and F, and post-separation, we want to keep that the same, at least for a few years for our kids, you got to write that down. As Neil said, the laws were written to serve the greatest majority, not to serve your relationship. And every prenup is as unique as the individuals in that relationship. So let's switch topics now. I hope we've convinced you that you need a prenup, regardless of whether you're that fresh 20-something out of college, or whether you're on marriage number 2 or even 3. if you need a prenup or a postnup or a relationship agreement to protect you. So what kinds of things can go into a prenup? Erin, do you ever put any kind of budgeting, forecasting, or how people are going to divide their finances into a prenup?
Absolutely. That's one of the things that's probably the biggest thing we talk about, besides, what do we own, what do we own and what do we owe? How are we going to handle the finances? Are we going to have joint bank accounts? Are we going to have separate bank accounts? How are we going to fund those things? What things are important for us to spend money on? Who's going to spend the money on them? What are we going to do if something's important to one of us and it's not important to spend money on for the other? Having that conversation, not a strict budget, like we're going to sit numbers in there and those are the numbers with. No, but a general idea of how are we going to handle our family finances on a day-to-day basis is really important to talk about and to put in one of these prenuptial agreements or postnup.
And with these nuptial agreements, postnup, prenup, all of those things, one of the big things in this area, and I would venture to say most, but certainly in this area, is disclosure. Neil, you had an interesting comment on our prep call about how disclosure can be really helpful in a marriage to begin with.
Yeah, I think if you're having this conversation about finances, both from a perspective of how are we going to operate it in our relationship with respect to money, as well as the full disclosure necessary when you do a nuptial agreement, each party has to fully disclose all the assets that they have, so there's nothing hidden. If you just have that conversation alone, you are ahead of the vast majority of people who enter into marriage or enter into committed relationship. Can't tell you how many clients I saw in family law where they really had no idea what the other partner's assets were. I had clients come to me when they wanted to do a nuptial agreement, say, yeah, I'll tell about everything except, the condo in the Cayman Islands. Nope, you got to disclose everything. And so just that alone, having that discussion about finances and assets, again, puts you light years ahead of most folks. And hopefully will make your life, smooth sailing or smoother sailing down the road.
And doing that, I think, really cements your financial relationship with your spouse, knowing, okay, we have, or you have, depending on how you decide to define your money, X number of dollars in this account. You have a retirement account over here. You have an investment account over here. Don't forget that, condo in the Cayman Islands. I have this restaurant. I have and those are for higher asset folks for the things that I'm talking about. But even for those that don't have a lot of assets, knowing where those things are can put it on the table for discussion, can open it up. Money, historically, and I would say especially for women, and I'm being a little gendered when I say that, but especially for women, is really hard to talk about. Women have a very hard time, and men too. We're socialized that money is something, you don't talk about in polite society. Yeah, you might say, I got that handbag on sale, but you don't say, hey, this is the percentage I got on my mortgage. When I got my latest mortgage, or hey, I negotiated this credit card interest rate down to this. Isn't that fantastic? And that's a broader conversation, but within your marriage, money should not be a taboo subject. And this is the way to start that.
Yeah, and can I just kind of bring the perspective of being an old guy to the table? Because in my lifetime, I've seen how finances are handled within marriages just make a tectonic shift. Back in my day, one person handled the finances and the other person oftentimes was completely oblivious to how that worked. One spouse did the booking. I know my own family, my father brought home the check, handed it to my mother, she did all the accounting, paid all the bills. He had no idea how finances in his family were managed. Then as I got older and became a family law attorney, I saw so many couples who took a different approach where they said, okay, I'm responsible for these bills, you're responsible for those bills, and whatever money you have left over from your paycheck after having paid your bills is your money. Okay. I'm not sure that I ascribe to that process, but that is the level of change that we've seen in terms of how finances are managed. And so you need to understand the ramifications of all of those choices when doing an agreement.
Absolutely. So, Karen, real property. And for those who need a definition of real property is property that is land-based, whether that's a condo, whether that's actual land, whether that's a house. If you own real property, whether again with a prenup, postnup, or no nup, what kinds of things can we put in a prenup about that?
Well, a lot of times when people buy property, especially when they first gotten married, the money that goes to put on a down payment, for example, on that house may not be what a family law attorney, a divorce attorney would say, oh, that's marital money. So you have to have an agreement about what happens to that money if we sell the house. What happens if we sell this house and we buy another house or maybe 3 more houses? What happens to that initial money that we put down? Who's responsible for the payments of the mortgage? I mean, I know what the mortgage company would say, but between us, who's responsible? How are we going to deal with decisions to sell it, refinance it? How are we going to deal with improvements to it? How are we going to handle all of those things related to the house? And what happens to the house if something happens to one of us? There are automatic things that happen if you title property in a certain way. If you title it as husband and wife, it automatically goes to your spouse. But maybe you're having a conversation about what happens. Do we title our property that way, or do we title it some other way? Depending on what it is we want to have happen to that property when it's sold, when somebody dies, or gets divorced.
The titling is really interesting. I'm thinking of a postnuptial agreement that I wrote this year where the house was in wife's name. It always was wife's. It was wife's prior to marriage. And one of the things that we put in there to protect husband, and wife actually suggested this, was if they ever got divorced, a notice provision, so that, instead of the statutory amount of time for how long husband would have to move out, we extended that significantly, created a nice way of doing that so that it wouldn't be, it would still problematic, someone has to move out, but that it's done so in a manner that fit the way they would want to end their marriage should they ever choose to do so. And I know that putting in there those kinds of protections, especially if a couple chooses to put a house in one name instead of both, and there are a lot of good reasons why that might happen. Maybe somebody's credit score is really not great and would hurt the mortgage, the mortgage interest rate. Maybe somebody's family is able to lend money, but only if in those situations. So you do want to put those kinds of protections in there for yourself and for your partner. So Neil, what about retirement? What can we put in prenuptial agreements about retirement?
Well, retirement is really an interesting perspective or issue to deal with, because you've got a lot of different kind of laws intersecting around what you can and can't do with retirement funds. The bottom line is you want to be very clear as to where the retirement accounts are, whose name they are in, and you want to make sure, this really goes for a lot of different aspects of the agreement. You want to make sure that it works properly with the other legal documents that you have entered into. So for instance, if you have a 401k savings plan and you have a beneficiary statement there, you want to make sure that the logic of that kind of dovetails with the logic of your prenuptial or postnuptial agreement. They're for different time periods, and they come into play based on different events. But by the same token, you want the logic that governs them to be appropriate. There's also an understanding that, and this goes back to the details of the underlying justification for family law legislation, that says that even if your retirement account is in your name and is generated as a result of the work that you do yourself, during the period of time that you are married, it becomes technically part of the marital estate, or a portion of it becomes part of the marital estate. And so I think you want to have that resolved so that you can avoid having to what we end up calling a quadro or other order from the court upon the dissolution of the relationship, as how to pull money out of that retirement account, if, when, and how. So it just makes things enormously more simple if you deal with the funds in your retirement plans ahead of time, rather than under the duress of a marital or relationship breakup.
Karen, talking about support, and at this point I'm talking about support for the other partner, not child support. What can we put in a prenup about that?
Just about anything you like that's not contrary to public policy or illegal. So you can put in how long we have to be married before you're entitled to support. What happens, like we were talking about earlier, what happens if we had children and one of us stayed home? Is there support? How are we going to determine the amount of support and the length of time for that support? Are we actually going to ask for support, or are we what they call waiving it? In other words, giving up the right to ask for support. Is any support going to be modifiable? Is the court going to, are we giving the court the power to change the amount of support if circumstances change? Or is it going to be what's called non-modifiable, which means what it is in the contract is, and nobody can change it? You can do just about anything you want with support. You can tie support. You can tie support to marital misconduct, length of the marriage. You can do just about anything that you want in terms of what makes sense for supporting your spouse after the marriage ends. You see this a lot, like we were talking about. You see it a lot with people who are having children, and one person is either going to stay home or they're going to put their career on a back burner. You see it a lot with people who marry someone who is economically superior, and they're never going to be able to earn any kind of living that's even going to give them what we would call a decent standard of living after the divorce. And maybe that spouse is taking on lifestyle or duties because of that marriage for the person who has a lot more money. Maybe you have a spouse who has an illness. Maybe they've given up other benefits in order to marry this person, monetary benefits. And so you want to provide for that. What happens if I can't get my benefits back? What happens if I've given up all this money and these entitlements to things, and our marriage ends? How are we going to handle that? You don't want to leave it up to a court. A court is going to, even though they're well-meaning, and the judges are well-meaning, spousal support is up to factors that the judge can interpret based on what you present before them as facts and what their life experiences are. And do you really want to leave the support of your spouse up to somebody else's life experience and not yours? I wouldn't.
I wouldn't either. The other part is, even if you don't take it before a judge, even if you work it out in a mediation or a collaborative process, at that point, people are, and we, as much as we as family law practitioners try to work with them, they're operating on a fear-based model at that point. You're afraid of what your future is going to look like. You're afraid of what your finances are going to look like, whether you're the payor or the recipient. And it's very hard at that point to look at, from a truly neutral perspective, of what's best for both of us, what's best for each of us, and what we need. You're in a much better place to do that at the beginning of your marriage or during your marriage when things are going well, for you to really come up with an equitable result for them. And I know a lot of people who are very against alimony or spousal support, period, end of discussion. I'm here to tell you that's fine, as long as you marry someone who also feels that way. But at the same time, maybe the answer is to get creative. I have certainly written prenuptial agreements that say things like, for example, if we have been married 10 years, I will pay my spouse X number of 100, sometimes 100, one of them was $100,000. That is the support. Good luck after that. Figure it out with that amount of money. Or I will set up a trust for my spouse after 20 years of marriage, and that trust will contain X, Y, and Z. My spouse will be the beneficiary, someone else will be the trustee, and that is how the support will get paid. There's lots of different ways to look at it, but at the end of the day, it's a conversation you have to have. If you don't have that conversation before you get married, you're really doing yourself a disservice, and your spouse a disservice.
Well, and I think also you have this a little bit when you were talking, that you want to have this conversation when you're in a place of abundance, because it's not fear that you're at the time of a divorce. You're in a place of scarcity. You're in a place where I worry that my fear is I'm not going to have enough, whether I'm the payor or the payee. And that's not a good place to be when you're having a discussion about what you want to have happen to this person who at one point you loved and wanted to spend the rest of your life together with. You want to have that conversation in a place of abundance of spirit and a feeling of abundance of resources.
Yeah, without that, it becomes an arm wrestling contest, and the only way to judge the winner versus the loser is who gets the most, and that's the wrong. That's just the recipe for pain.
So in the state of Maryland, we do not divide debts unless there is a specific type of marital debt that is tied to a specific marital asset.
Which is a huge shock to most people.
Huge shock to most people when they come and go, wait, all the joint credit card debt, we're jointly liable equally? Yes. Fun. Dividing debts in advance is something we can certainly do in a prenup or a postnup. Do you have any thoughts about that, Neil?
I think that is, again, for many a young couple, that is the most important element of their prenuptial agreement. They don't have a lot. The biggest thing they have is debt. Okay. And so contracting for how to manage that debt if the relationship ends is in many ways the single most important, other than children and all that, which is not part of the agreement, but it's the single most important question, I think, for most people in this day and age. When you think about it, a recent study said that the vast majority of Americans don't have any savings. They couldn't handle an unexpected $400 bill. So we're not talking about people who have lots of resources and lots of assets. We're talking about regular Joe American, Jane American, and the thing they own the most of is debt. So absolutely understanding what that is and who's going to be responsible for it and how you're accumulating it. Again, it's just shocking sometimes how many people come to our offices as family law attorneys and they really have no idea how they are acquiring the debt, in whose name it is being placed. And the biggest revelation of that is when they start to split it up. And they went, wait, it's all in my name? How did that happen?
One of the first things when people come to my office for a divorce consultation, I say, pull your credit report, bring it. I need to see it. And it's the rare person who has pulled their credit report within the last year and has actually looked at it to see what's in their name. The other thing that always makes me cringe, and this is for the younger people, a lot of us will, I refinanced my law school loans, but I did not refinance them with someone else. A lot of people will take advantage of refinancing them together as a married couple. And if you don't have that in your prenup or a relationship agreement, I see that walk in my office and I just take a breath because I'm like, oh, I'm going to have to explain this and it's going to be bad. You immediately know you're going to be delivering bad news.
And the most aggressive debt collector is Navient. One of the people who manage student debt.
Yeah, they don't mess around.
They don't mess around.
Not even a little bit. So if you're going to take advantage of some better interest rates by refinancing together, that's fantastic. You better get a prenup or a postnup and make sure that you have a plan for that, so that if something happens, and for that, it's not even just if something happens to your marriage. If something happens to your other spouse, that's something that you can provide for, whether it's through a prenup or estate planning or a combination of the two. Life insurance, for example, is a very good option, and having that go to an agreement that we have a life insurance policy, it's going to pay off the student debt. Okay, so Karen, can you specify anything about the divorce or separation processes in a prenup, postnup, or even a no-nup?
Sure. What kind of process would you like? You can put in the religious process. You know, a lot of religions have their own divorces, their own version of divorces. You can put in that they're going to agree to do that. I think that's really important, because I've got to tell you, in all the 30 years I've been practicing family law, I see maybe once a year, or twice a year, people who are arguing over religious divorces.
Oh yeah, they won't give a get, or they won't cooperate with a Catholic annulment, any of those fun things.
Right, because one party has to, in many of these religions, one party is required to do it and not the other party. And if they don't, the other spouse is stuck. So I like putting that in. And what process we're going to use to resolve any issues that maybe we didn't deal with in the prenup, or that we couldn't deal with in the prenup. What process are we going to use? I'm the process girl. I love process, because process determines outcome. And the more control you have over your process, the better your outcome is, because you have more of the say and more control. So I love to put in those processes like mediation and collaborative law, because those processes are processes where people have control, and you're not sitting there waiting for somebody else's determination or the court's docket, which right now in this lovely COVID-19 era could be a very long time waiting indeed, with the courts being closed. You don't want to wait on somebody else's timetable, and you want to make your own decisions. And so I always recommend putting in a process for dispute resolution. Absolutely.
I do as well. The other thing that some people will do to make their marriage stronger, or make it harder to get out of, so that people have to really think about it, is I've seen a few different people want to put in their prenups things like, we must engage in 6 months worth of marriage counseling before either of us files for divorce, seeks the mediator, whatever else. And that is something it used to be. It's something you used to be able to do in a covenant marriage. I don't know that most people do a covenant marriage anymore, but it is something that you can put in your prenup or postnup, that, hey, we realize that as we grow, as we age, as we move on in our lives, there might be a time when one or both of us wants out of this thing, but we agree that we're going to give it one good college try, and we're going to go to, a professional and try it. And if it doesn't work, then the next step is a mediator, a collaborative divorce, whatever else it might be, to keep things nice and peaceful. So those are different parts of it. And while we're going to get to the kid part in a second, one thing I also wanted to highlight is, while you cannot, and again, we'll talk about this in a moment, decide custody of your children in a prenup, you can put things in there like, we will consult a child expert before making any decisions about our children. So putting things in there that will protect your family later is certainly a good thing. College savings, is that something that can go in a prenuptial agreement? Saving for college, whether it's for you, because again, we have some of those young folks getting married and maybe wanting to go get a PhD. Who's going to pay for it? Whose income is going to pay for that? And does that affect anything else later? Or also any kids that might. Karen, I'll point to you on that one.
Well, sure. Of course you can put that in there. And in fact, you should, because under most state laws, some states are different. Some states do provide for child support through college. It includes college educations in there. Most states say, for example, for children, most states say child support ends at age 18 or graduation from high school. So having a conversation about how important college education is to you is really important. I mean, I can't, when we're negotiating a separation agreement, when a marriage ends, that's probably one of the more contentious issues that I negotiate, because parents find out, because they didn't have a prenup or a postnup, that they have very different ideas of the importance of a college education, how to pay for a college education, how important are loans, and things like that. So that's really important to have that conversation. It's also important when you're talking about a spouse. If I put you through college and you become the most world famous doctor or dentist, and you have this practice, does that mean anything later on that I help pay for your college education? And do I get some compensation for it? Because the law, if you left it to a judge, depending on, right, depending on, you're not going to get any part of that degree, but depending on what kind of practice they have, whether the practice has a value is the only thing you're going to get. So if you want to get some return on your investment, so to speak, or you want to talk about, do I get brownie points for being a good person and helping pay for your college, and we agree to that, you want to put that in there. And also, at the end of the day, the other argument I hear a lot of is, well, you should give me more because I put you through college and I sacrificed and I worked 4 jobs to put you through college, and that has a value, which in my litigation mode, in my traditional lawyering mode, really doesn't have a value. It has a value in other processes, and it has a value when you're negotiating one of these agreements, because again, you're in a place of abundance, and you can reach an agreement so that you don't have those recriminations at the end.
So Karen touched on this, and I'm going to touch on it a little further, and that's the issue of business valuations. So if you own a business, you want to have a value at the time of your marriage. And here's why. In many different states, and Maryland is one of them, any increase in the value of a business during the marriage is marital, in the same type of way that an increase in your retirement account is marital. One of the most expensive parts about a divorce when there is a business involved is trying to go back and have experts trace and make guesses, educated guesses, but guesses on what was the value at the time of marriage and what is the value now. It's based on a lot of assumptions and a lot of different things. So if you can agree on, hey, we're going to agree that as of today, my business is worth X number of dollars. Or if you're going to waive any interest in a business, so you're going to waive any interest in that increase and exchange it for something else, that's another option. But these business valuations, if you are a business owner, if you're an entrepreneur, or if you are planning on becoming one, that is something that I think is really important to consider, is protecting. And it really is protecting each other. It's protecting each other from a protracted expense of figuring something out later that really can more easily and really at less cost be figured out now. Okay, so Neil, I'm giving you the floor on this one. Trust and estates. What can we put in about estate planning in a prenup? And for full disclosure, if I write your prenup, I'm sending you to Neil or someone like Neil to look over the estate planning portion to make sure it jives with your estate plan and to make sure that those portions are congruent and work with each other, because they are 2 documents that really, they have to work hand in hand. You can't have one say something different than the other.
Well, that's exactly right. And I was going to, there's a lot of little nuances, but let's deal with the 2 really big perspectives on the interplay between prenuptials and estate planning. And the first and most important one is, just as you said, we alluded to it earlier when talking about retirement plans. You want to make sure that the prenuptial agreement and your estate plan work together logically. Now, the 2 legal documents control different events. One has to do with the dissolution of a relationship, and one has to do with the death of a family member or a spouse. And so which takes precedence? Well, it depends on what part of the argument we're having this discussion about. But what you don't want is, say, to make it in the most gross example, that in the prenup agreement, one spouse gets the house upon dissolution of the marriage, and in the will, just the opposite is the case. Because what that does is it provides all the fuel for a dispute later down the road. So one's gonna carry the day, but you really don't even want that kind of controversy, because all it means is more money for the attorneys, frankly, and more headache for you as an individual. The other major aspect of the interplay between the two has to do in the back end frequently of the document, of the prenuptial document. You have all the kind of important stuff, and then towards the last quarter of the document is the stuff that most attorneys say, well, that's kind of the legalese, and that's kind of the, the disclosures and stuff we got to put at the end of the document just to make it legal. One of them frequently has to do with the waiver of the elective share. And just to kind of tell you what that is real briefly, is that the legislature, the statute provides one spouse to take an elective share of the other spouse's estate upon their death. And that can be as a result of them dying without a will or even in contravention to that will. So let's say the will says, I'm going to give 10% of my estate to my wife. And the wife said, wait a second, how did that happen? I've been here for 50 years. And so the legislature says they can choose to ignore what the bequest was in the will and instead take a percentage of that estate as their elective share. So that's to protect people. And frankly, historically, it was to protect women because guys were being unscrupulous and putting all their assets in their name, and then when they passed away, the wife would find she had nothing. There was nothing in the marital in the estate, not in the marital estate, nothing in the estate from which she could inherit. So this kind of gets around that. Now, and there's been some recent changes into the elective share that makes it even more important. But what the prenuptial agreement does at the end, you can choose, it doesn't have to be this way, but you can choose to waive that right to take the elective share. And why is that important? Well, what happens if there's you pass before the will is drawn up, as an example, or even before the marriage ceremony occurs? You entered into this agreement. Do you want the signatory of that agreement to be able to take the statutory share from the deceased estate or not? And so it clarifies that issue. So I know for a lot of family law attorneys, they may not pay a lot of attention to that part of the prenuptial agreement, but it is important. And even more so, I've had several people have come to me as an estate planning attorney. And I had one in particular who'd been separated from her husband for 39 years. Okay. Now, still subject to the marital share, elective share. So even though she'd been separated, without that agreement waiving that right, the estranged husband from 29 years still had a right to her estate, a portion of her estate. And that's something, just a funny aside, I asked her at one point and said, well, in those 29 years, why didn't you think to actually get divorced and resolve this issue? And she leaned over the table to me and said, Sonny, which is when you're deferring to your elders. She said, Sonny, I made a promise in the house of God, and I'm not going to break that promise. I may not want to live with the guy for 29 years, but I'm not breaking my promise till death do us part. So anyway, those kinds of things come into play when you're trying to figure out your prenup agreement.
Thank you. And I agree wholeheartedly. The trust and estates portion is something that if you're prenup attorney, whether you're hiring Karen or whether you're hiring me or Neil to look it over, you need to make sure you're paying attention to. If your attorney's not paying attention to that, ask about it.
Yeah, and particularly also if there are trusts involved. Let's say one spouse is the party to inheritance through trusts or an ongoing inheritance. You want to make sure that the dissolution of the marriage addresses that issue.
Absolutely. All right, so what kinds of things can we not include in a prenup? So I'm going to start with the one that everybody always asks. Everybody asks. It's sex. They all ask about it. Can I put in there that we have to have sex 3 times a week? Can I put in there that, certain sexual acts must occur or must not occur? Let me give you the short answer. Yes and no. yes, people do it. I've seen weird ones like that. But no, I'm not going to do that for you. And here's my stance on it. And then I'll let Karen and Neil say what their stance is. My stance on it is, if you are in any way having a document that could be interpreted as exchanging sex for me, you might have a document that's suggesting you're doing something illegal. So I don't recommend it. If you and your spouse want to, or future spouse want to have that conversation and want to have your own agreement, I wouldn't put it in a public document, and I wouldn't put it in a document that could be interpreted in any way, shape, or form as exchanging sexual. Neil and Karen, what are your thoughts on that?
Well, I've had it come up a couple of times, and in both occasions, it came up in the context of the couple had an open relationship, and they want, and the premise of getting married was to be able to maintain that open relationship. Now, I don't really understand that. I'm old school, been married 39 years and to the same original woman. So I don't really quite get that. But suffice it to say, look, it's a different world these days. And so that's the scenario that has been presented to me. Open relationship, open marriage. We want to put in the agreement that adultery will not be grounds for a divorce.
That I've seen in there.
Yeah.
I've seen that I can get behind.
And that, but it's still a little difficult because I always wanted to phrase that as that we agree that we are not going to address our open relationship in court, to put it that way. Okay, just to couch those terms a little differently.
I think you could definitely write that in a way that is not appearing to exchange.
Right. Well, and also remember, if you ultimately do get a divorce, or somebody is challenging a will and they're using their premarital agreement to do that, that agreement's going to be a public document. And do you really want sex life to be a public document?
All right. Can you put in the prenup that your partner can't gain weight?
I hope not.
This one falls for me under, yeah, you can, but do you really want to? Do you really want to? Think about that real hard. And if your partner wants you to, you really want to marry that person.
Well, I think that's an important consideration, Christy, because for us as attorneys, yes, we can craft the agreements to incorporate that kind of thing. But the first thing it does to me is it raises a huge red flag, and so if it does, and you kind of come to grips with that, then the process of discussing it is worth the money that you've paid anyway.
Absolutely. All right. So those kinds of sexier things that you see on TV, I remember a very fun scene in Maid of Honor where Patrick Dempsey's character's father was negotiating a prenup on the on the church steps. That included a lot of things such as how many times they would have sex and who can gain weight and stuff like that. That's TV, not reality. Another part of that TV part is do not negotiate your prenup on the courthouse steps or on the church steps. You want a nice cushion between the time you sign this thing and the time you get married, and then you want to reaffirm it after your marriage and say, "Yep, we thought about it, we got married, and we still agree with it." And as I said before, a prenup or then becomes a postnup or a no-nup is a living, breathing document. As you and your marriage change, as you and your circumstances change, you want to revisit this. I would recommend revisiting it every 5 to 10 years, or more often if there were major life changes. Okay, what about children? What can you put about children in a prenup that would be enforceable, and what can you not put in an agreement about children that would be enforceable? Karen, I'm going to start with you on that one.
Well, there are a lot of things that you can't put in. Why don't we start with that? You cannot put in an agreement what the custody of your not born children or even your then born children are going to be in the event of your divorce, because the court's going to say you can't foresee what your children will be like whenever that divorce happens. So we're not going to enforce something that says that this is what the custody arrangement of your child is going to be moving forward. You can put in things so that the court can't do. So a lot of marriages that have prenuptial agreements have stepchildren. And you can talk about aspirationally, especially what you all intend your relationship to be with your stepchildren, if both, during the marriage and beyond the marriage. And do you intend for that to continue? You know, is it enforceable in a court of law? I'm not really certain that it would be, but still, it's an aspirational thing you can discuss. You can discuss, whether one spouse, you can put in there whether you think one spouse is going to stay home with the children or not. That you can put in. But can you then translate that to what happens after the marriage? No. Can you put in things about child support? You're supporting your children. The answer is, I like your answer before, yes and no. So the yes is the thing, if you agree to an amount of support that is greater than what the law would order, sure, you can put in child support. If you are putting in things that the court cannot do, like the length of child support, that it exceeds what the court would award, that it provides for support of stepchildren, for example, that it provides for college education. Those kinds of things can be enforced in an agreement. You can put in raising the children's religious preference can be in and it can't be in. Courts are sort of reluctant to order that a child be raised in a certain religion, but they will talk about and enforce something that says that this is what the child is raised, how the child is raised. And if a parent does something that would harm the child by changing their religion or affecting it later on, then I think the statement in the prenup might have a lot of weight.
The other things that, I agree with everything that Karen said, but the other things that I put in prenups that may or may not be enforceable, but would absolutely be persuasive. And persuasive to a court can often A, save you a lot of money, and B, save you from a problem later on, is putting the schools in which you want your kids to attend. If you, for example, if you live in Montgomery County, Maryland, where all three of us live, and you want to agree with your spouse, our children will be raised there, that can be persuasive if later one spouse wants to leave. Not, again, definitive, but persuasive. I think religion can be persuasive. If the two of you agree in your prenup or postnup, we're going to raise our children Jewish, for example, and then later there's one parent trying to change their religion, a court might consider that in deciding who, for example, would have legal custody or have tiebreaker, who stuck with what you did before, and things like that. Other persuasive things might be at the time that you're going to have your children be with grandparents, especially if you're going to have the children live with the grandparents for an extended grandparents' rights are a very hot button issue, and there are some rights, but not a lot of them. But yeah, and I don't think you can create new rights, but you can certainly provide the court with an avenue to look at, and an intention to look at. So these are some of the things that I still recommend that couples look at and think about, even if they're not necessarily going to be enforceable. And just so you understand why it's not enforceable in a court of law right now. Courts do not like you to make decisions for your children before it's time for those decisions to happen. You don't know if who your child is going to be from a baby to age 5 to age 15, and what their needs are going to be as a 15-year-old when you're trying to decide those decisions for a 5. They might have very different and specific needs, and the court wants to address them as they are an independent human with their own needs, wants, desires. Okay, so those are our big questions. The last question that I want to talk to you guys about before we wrap it up is process for a prenup. Do you need your own lawyers? Should you go on LegalZoom? How do you handle this? Karen, why don't you say how your office handles it, and then we'll kind of go around robin with this one.
Well, if you're asking, do they need a lawyer? I'm going to say yes, and not because I am a lawyer. Because people would say, oh yeah, you're a lawyer, so of course you say that. But no, you need a lawyer because there are things that we're all bringing up, and there are more things that we know based on working with the court system, working with a whole lot of agreements, knowing contract law, that we're going to know that you are not. And this is an important document, and this document can determine what happens to you in the future. And so I always tell people, it's worth a little bit of money to get some legal advice, so that you know that you've hit all the things you need to hit, and that, if you need to go and call an estate's attorney, you need to do that, and so you're fully informed. I mean, do you have to have an attorney? No, you don't have to have an attorney. Can both people come to the same attorney to draw up the agreement? No, they can't. We're not allowed to represent both sides to an agreement. We can only represent one side. If you need help making that decision and you want to talk to a mediator, then sure, call me as a mediator, and I'm happy to help you mediate the things that you can't agree on, or to help you issue spot things that maybe you need to put in your agreement that you hadn't thought about, so that then you can go to your attorneys and have them draw up the final agreement. But yeah, I think you should have an attorney.
So I agree with everything Karen said. As a mediator, happy to work with both parties to help them have that discussion. And sometimes it's really hard to have that discussion. So having a mediator help you guide it, it's certainly, but having an attorney explain your prenup to you is worth every dollar. And I say that not just because I am an attorney and not just because I write them. I actually am a big believer in legal tech, and I think the law should be written in such a way that you can do it yourself to an extent. But this is a life-defined roadmap. And if you don't understand it, or if you made a deal, for example, I have seen a prenup where somebody drafted it themselves, where wife agreed, I will waive alimony forever, but I will get to keep the kids. And she thought that was a perfectly fair trade. Well, what the court found later was that the child part was not enforceable, but that alimony part was. So she had no alimony and had to share custody of her children 50-50, something she desperately did not want. And in her mind, but I made that deal. And if she had gone to any one of the three people sitting on this Zoom call and this webinar right now, we would have said, that's a bad deal. You can't do that. And it's for those types of reasons, an ounce of protection is worth a pound of care. Come to us when it's a paper cut, not when it's gangrene. Neil, what are your thoughts?
Yeah, I would add one little other thought there, that the agreement is between two people. Okay. The role of somebody's family, extended family, shouldn't play a factor. Now, you hear it all the time. Her parents made her get a prenup because her parents were, the economically advantaged party in the room. I've even had, dads bring their little daughters into the office. I want a prenup for her. I'm paying for it. And then they want, which is fine. That's okay. That's perfectly permissible. They don't get a voice in what's to be included. Now, what happens away from your office behind their own closed doors, that's another thing. But just I always try and emphasize to people, it's between you two. Okay? It's not what your parents think. It's not what your grandparents think. It's not what your brothers and sisters think. Again, I've had some folks from cultures where the older brother sets the rules. Okay? That's not the case here. So just keep in mind it's between two people.
I hope we've answered lots of questions about prenuptial agreements. If you are watching this, you'll be able to see at the end all the contact information for each of the people on this call. We want to make sure that we are happy to talk to you about your prenup or about your estate planning or about your divorce. I know each of us have some things that we're doing right now, just pivoting slightly during the coronavirus with everybody stuck at home with our own individual practices. So I wanted to give a minute for everybody to say what we're doing and what our additional offers are, should anybody be interested in those. Karen, would you like to start?
Well, I'm still fully operational and in this coronavirus. My office has been fairly virtual for a lot of years. So we're still up and running. We're using a lot of Zoom and Google Hangouts, and we're still doing initial consultations. I'm doing mediations by Zoom, parent coordinations by Zoom, collaborative cases by Zoom. We're still doing everything that we can do. We're also very happy to talk to anybody who has basic questions about their marriage, their custody, their child support, their alimony during this during this pandemic, we realized that this is an unusual situation, and we're providing some limited services for those people who really need some advice during the coronavirus.
Neil, what's your firm up to?
Yeah, well, estate planning firms, as you might imagine, have taken on more importance, sadly, as a result of the coronavirus pandemic. One of the things that I wanted to do, and I have been doing, is in an effort to give back to the community, and in particular, to thank those first responders and nurse practitioners and people in the medical community, is to be able to do, or an offer to do, what we call an advanced healthcare directive, sometimes referred to as a medical power of attorney, that gives somebody that you designate the authority to make medical decisions on your behalf if you're not able to make those decisions yourself. Let's say you're intubated, okay? I do those for free. No strings attached, no games being played. If you are an EMT, a nurse, a physician's assistant, somebody working in the provision of services to those being afflicted by a coronavirus, I'm offering to do that document for you at no cost and no strings attached. If you want to go a step further and you want to have a will-based estate plan done, what we're offering is a greatly reduced bare bones will. Look, it's just covers the minimum, but then you can upgrade it later when the crisis passes. That gives people a lot of comfort and addresses the concern that they might have. Hey, I don't have a lot of money to do that right now. Okay, well, let's do a bare bones version for a minimum price, and that way you can upgrade it later as the need arises. So those are the two things that I'm trying to do within this crisis, to try and give back to the community and to say thank you.
Thank you, Neil. So Z Family Law, we have started a COVID-19 resources page on our website. Our resources page includes information about the courts and what's happening, information for domestic violence survivors, what's open, what's available. We're updating it on a weekly basis. We have some of the organizations thankfully sending us their information. Other ones we're calling and reaching out because we want to know if you're in trouble, you have a place to go that you can see what's open, where can I go, where can I walk in, where can I call. We also have information for parents as far as how to talk to your child about the coronavirus. What can you do to entertain your child? How to homeschool on a fast turnaround, and how you can work on that. We're also continuing to do webinars like this. We do have one coming up on April 16th with regard to child support. If you have lost your job, if you are furloughed, if you are laid off, if your business has taken a hit, you cannot afford to wait to do something. You cannot afford to wait. We cannot go back in time, even though the courts are shut down, to before your date of filing. And you need to know that. We're going to be discussing that on April 16th at 4 p.m. We also have been providing low cost, like Karen, we've been providing a lower cost consultation for those who have questions specific to COVID-19 and these stay-at-home orders. If you have a custody order right now and you're not sure what these stay-at-home orders mean, or if you have a valid reason to violate your court order, not that should be your default, but there are valid reasons out there right now. Talk to us. We are flat feeing them at $100 for a half an hour. We will review your custody order. We will talk to you about it in conjunction with the stay-at-home order, and we will help you make a plan and figure out what to do. We also are fully operational. We have not stopped. Z Family Law has been virtual pretty much since its inception. So for us, we picked up our laptops and we went home, and have been working here ever since. So if you need us, we're here. All right. Thank you so much to Neil Tyra and to Karen Robbins. I really appreciate you guys being on here. Again, I'll link all of your information to this video, and we really appreciate your time.
Thanks, Christy, for putting this together, and I'm very honored to be a part of it.
Thank you.
Thank you, Christy. This has been terrific and a service to the public.
Thank you. All right. It's nice seeing you guys. Have a good rest of your day.